All right, we're going to get started. Good morning, everyone. Thank you again for joining us. My name is Kripa Upadhyay. I am an immigration attorney here at Cartottle Campbell. I am joined this morning by Joshua Howard, who is an associate attorney with the employment law team here at KTC. I guess, agenda for the rest of the time that we're together is going to cover both employment and immigration law issues with respect to foreign national employees and just terminating employees given the current market conditions. We would love your questions, and so to the extent that you have any, please do send those in via the chat or the Q&A function, and we will get to them preferably as the slides are going through. But if not, we will get to them at the end of the employment law section, which is going to be the first thing that we cover, and then later on the immigration aspect of things. But if you have any questions, again, feel free to put that in the Q&A box or the chat box, and we will be monitoring that. And so moving forward, Josh, if I may please have you introduce yourself.
Great. Yeah, thank you, Kripa. My name is Josh Howard. I work in our employment department here at Cartottle Campbell. I have a lot of experience in compliance work with wage and hour issues, leave laws, and unfortunately a lot of experience with terminating employees and all the intricacies that go into terminating an employee. So what I'm here to talk about today is kind of the employment law issues. You'll see my profile up there along with Kripa's. Kripa's going to be taking care of the immigration issues today. So if we can go on to the next slide, I'll start my agenda. So if you're here today and you're considering a layoff, I just want to let you know that you're not alone in the market. You've seen a lot of layoffs in the news, Amazon, Facebook. There are a lot of layoffs going on right now, and it's not a fun thing to do. It's a pretty intricate process, and you want to do it right when you're laying off a bunch of employees. So I'm going to take you through some of the common employment issues that come up with layoffs. And the first one is the WARN Act. What notice do you need to give when you're laying off mass groups of employees? There are specific federal requirements for that notice, and so I'm going to go through that with you. And then executing layoffs. And here I'm going to really talk about how do you select employees in an objective, non-discriminatory manner for the layoffs. This is probably one of the stickier issues. It's something that you probably are thinking about. Like if you want to lay someone off, how do you choose? Do you draw names out of a hat? I will go over some options with you and some things to consider when you're choosing. And then I'm going to also talk about severance agreements in the Older Worker Benefit Protection Act. Severance agreements are good to protect the company in mass layoffs because it mitigates risk during the layoff. So there are some things you need to pay attention to when you're specifically asking older employees to waive their rights. So if we could go to the next slide. So the WARN Act. This is the Federal Worker Adjustment and Retraining Notification Act. It's a fancy acronym for the idea that you need to warn the state if you're going to do mass layoffs. It is administered by the Employment Security Department. It requires employers to provide advance notice or warn of mass layoffs 60 days in advance. The covered entities are employers with 100 or more employees. This does not include part-time employees, and part-time employees are considered those that work less than 20 hours a week or have worked less than 6 of the last 12 months before notice is due. Again, this is administered by the Employment Security Department, so there are plenty of forms on there and plenty of information on the Employment Security Department website to help you navigate what you need to fill out and what you need to send in. Now for the covered events. WARN doesn't apply to every layoff. It only applies to permanent or temporary mass layoffs or plant closings. So as a lawyer, you kind of look at this and you want to break down what does each of these words mean. So permanent or temporary first. It includes any loss of employment that exceeds a 30-day period. So if you if employees are taking a short time off and you have to close a plant down for 20 days, that doesn't count. But if it exceeds 30 days, it does. Plant closings. This is the shutdown of a single site of employment or operating units within a single site of employment for 50 or more employees, excluding part-times. So a single site of employment would be like a building, an entire plant closes. My family works for Boeing, so when they do layoffs, they have these WARN requirements, and maybe the entire Frederickson plant has to be closed down, or just the tooling department in the Frederickson plant is closed down for a certain amount of time. Those would trigger your WARN obligations because it's a single site or an entire operating unit within a single site of employment. Now for mass layoffs generally, it's anywhere between 50 to 499 employees, excluding part-time employees, if they represent 33% of the total active workforce. So this is a fancy way of saying, if you're laying off more than 33% of your workforce and it exceeds, and that 33% exceeds 50 total employees, that's a mass layoff. So you can think of situations where, you know, you have 101 employees, but you're laying off 50, that's a mass layoff. But another employer has 300 employees and they're only laying off 50, that's not a mass layoff for that employer. Or if you're laying off 500 or more employees, excluding part-time, regardless of the percentage of your workforce. So again, this applies mostly to bigger companies like Amazon. Even though a lot of the recent layoffs are like a pretty minute portion of their overall employee base, they all exceed 500, so they still have to comply with the warning requirements. And now there's some exceptions to this. If you're a faltering company and you believe that a big public announcement of your layoff would cause your company to go under, and you're making good faith efforts to keep everyone employed, you don't necessarily have to give the 60-day notice. You have to give notice as soon as you're sure that you're going to be laying employees off. And that's the faltering company's exception. Again, this exception is somewhat complicated. And if you feel like you're in one of these circumstances, please feel free to reach out to counsel and we can walk through kind of what you're thinking with that exception. Another exception is unforeseeable circumstances. This is when you have the huge contract and someone pulls the rug out from under your company. You lose the contract and you expect all this work to be there for employees, and it's not. In that case, you also have to give notice as soon as you realize that you're going to have to lay off a whole bunch of employees. And then the last one is natural disaster. You know, you can imagine what this would be, you know, a tornado coming through the city and wiping out one of your plants. Again, you have to give notice as soon as possible, but you don't have to give the 60-day notice under the WARN requirements. Go ahead. And again, this information is available at the Employment Security Department. On the left, you'll see I'm signed up for WARN notices through the Employment Security Department. So this is one I received, 3 or 4 days ago, that 158 employees were going to be laid off by Microsoft beginning May 26, 2023. And there's also a good database that goes through all the WARN notices that have been filed with the Employment Security Department. I think going back to at least through the last 2 years. I think they keep records, going back at least 7 years. And for the next slide. Now for executing layoffs. When you're thinking about who to lay off in the workplace, the basic principle is that you want to use objective, non-discriminatory criteria. Now, what does that mean? I've seen people use last in, first out criteria, meaning that, oh, can you go back one slide? Thank you. I've seen people use last in, first out, meaning, if you're the last person hired, you're going to be the first one laid off. That would be a seniority-based criteria. You could use some mixture of performance-based and seniority-based. Maybe there are underperforming employees that you have a legitimate reason. Maybe you do have a lot of metrics on your employees and you want to lay off the bottom 10% of performing employees. That is a legitimate non-discriminatory reason. And then the final one is you can offer volunteers. I know companies like Amazon did this before doing forced layoffs. Is they offered people, once they announced did their WARN requirements and announced that they're doing these layoffs, they said, if anyone wants to volunteer for this, you can, and you'll get a little bit better severance package. That's something you can do. And then also, sometimes layoffs, if you're a union employer, sometimes layoffs are going to be governed actually by your collective bargaining agreement. So that's something that you should take a look at if you're a union employer. I won't go into that here, but if you have any questions on that, feel free to reach out to your counsel. And then you also want to think about, protected leave considerations. So one thing we get asked all the time is like, oh, I have a certain number of employees who are on FMLA, paid family medical leave. They're out on sick leave and they're going to be part of the layoff. Are they protected because they're out on leave? The answer is generally no. I'm going to use paid family medical leave as an example because it has the most onerous requirements for notice if you're going to terminate someone. But for paid family medical leave, there's a specific exception that employees are not entitled to job restoration if the employer is able to show that the employee would not otherwise have been employed at the time they were to return to work. So that would be a mass layoff. If their entire position is gone, then they're not entitled to job restoration. But you must give specific notice as soon as you decide that you're not going to restore their job when they come back. And that notice has to include a statement that you intend to deny job restoration, the reasons why you're denying job restoration, and an explanation regarding their health benefit eligibility going forward. Okay, I'm ready for the next. And then the final thing you kind of want to decide is if and when severance will be offered to employees that are laid off. Some considerations when you're thinking about whether to offer severance is maybe the employee has a contract that already obligates you to give them severance and you terminate them. This is more common in executive agreements, or high-level employees might have kind of a for-cause termination clause in their employment contract. So if you think, if you look at their employment contract and severance is offered under that contract, obviously you need to offer severance. And then also severance is really a risk mitigation tool. So the point of severance is to get them to release their claims against the company if they have any on their way out. So you don't have to worry about whole swaths of employees filing lawsuits against you after the layoff. Employees who have recently lost their job are typically not very happy with the company, so the risk is a little bit higher with them. And then for the specific severance agreement, you really need to consult your attorney to make sure your severance agreements are up to date. I know we presented on this before, but there are new restrictions to confidentiality provisions in severance agreements and contracts. And if you are using old templates, they might have unenforceable provisions that we need to look over before you present them to employees. And on a related note, the Older Worker Benefit Protection Act applies to employees over 40 years old and requires employees that are asked to release their ADEA claims, age discrimination and Employment Act claims. They're entitled to specific notice requirements if you're going to present them with a severance agreement. So under normal circumstances, if it's just one employee over 40 years old, they get a 21-day consideration period for the contract. So you present them with the severance agreement and they get 21 days to consider it. And then they also get a 7-day revocation period. So they can revoke their acceptance of the severance within 7 days. And this is increased to 45 days if you're asking more than one employee to sign a waiver of ADEA rights. And so this is particularly important in mass layoff situations where you're likely going to be asking multiple people over 40 to sign a severance agreement. So that should go into the planning of when you're going to present severance agreements to employees and whatnot. And then there's additional notice requirements if these employees are part of an exit program or a voluntary layoff where you're saying, hey, this group, we've decided that we're going to lay all of you off. And, if you guys all sign this severance agreement as a group, then you'll, get compensation exchange for a release of claims, including your ADA claims. You need to send a notice to anyone and everyone in that decisional unit, including the eligibility factors on how you decided who was going to be laid off and any time limits that they have to qualify for the severance agreement. So, obviously at least 45 days for those people who are over 40, they have at least 45 days to decide, but maybe you have a longer time frame where they can decide. And then you also have to disclose the job titles and ages of the people who were selected for the exit program and the ages of all who were not selected for the program. So, the purpose of this is to, be completely transparent with the ages of people that you're asking to leave the company and the ages of people that you're not asking. And if anyone has any questions, I don't see any in chat. I'm happy to answer them. If not, then I'm happy to, turn this over to Kripa.
Yeah, if you have any questions, feel free to send those over via chat. I don't know if I'm not seeing any at the moment, so I think we will continue on to the immigration portion, but if you do have questions, we can always come back to them. We'll definitely come back to them before we end the session anyway. So moving on to the immigration aspects of layoffs, to the extent that any of you have foreign national employees, so foreign national as in anybody that is not a US citizen or a lawful permanent resident, termination from employment is not just job loss for these individuals. It really sets off a domino effect for your employee as well as his or her family. So anybody that is in the US, any employee that you have that is working for you under a employment visa, essentially has 60 days from the last date worked within which to either find alternate employment or essentially pack up and leave. I mean, those are their two options. Immigration has taken a fairly hardline stance with respect to the WARN Act. So even though you may have a WARN Act in effect and severance, which takes you, let's say your termination date is April 1st, but then your severance actually takes effect, 3 months down the line, immigration takes a very hardline stance and says that severance is what they call garden leave because it's unproductive work time. And so severance period does not count for purposes of maintenance of immigration status. So in order to maintain immigration status, you have 60 days from the last date worked, irrespective of whether or not you are receiving severance. If you have employees that are in this position, they have very limited choices, unfortunately. One, and it's unfortunately one that my team and I here have used quite often in recent months, is to help these employees change to a B2, which is technically a tourist visa, and it's only meant for you to come to the US or be in the US purely as a tourist for tourism activities. But there is an exception with respect to foreign national employees, because you have to think about this in terms of this person having essentially left, whatever country they were living in and come to the US, they may have an apartment that has some sort of a lease provision on there. They have potentially a car that is being financed. They need time to take care of all of those things, right? And so it is possible for them to file for a change of status application to a temporary tourist visa, which would give them at least 6 months from the time of the last date worked. So they can extend that 60-day period to a total period of 6 months within which they can continue to be in the US. If they find employment within that 6-month period, they can then file a subsequent application via employment through the new employer as the sponsor, but that's an option. Similarly, the F1 is essentially a student visa, and there are certain programs and universities that they can apply to where they might be eligible to then convert from an employment visa to a student visa option. The O1 is extraordinary ability visa. It's what we in the immigration world deridingly refer to as mini Einstein. But the mini Einstein visa basically requires the applicant to show that they are essentially in the top 15% in their field, right? They've had articles written about them, or they've won national or international awards. They are very well respected, thought of as a subject matter expert within their field. And that is an option as well. The E2 or the EB5 is not employment-based. That is purely individual petition for any of the employees that may have financial means to be able to now convert into the status of an investor. But all of these applications can be filed within that 60-day period, so your employees are not having to face essentially leaving the US. I actually covered most of this. Now, the one thing that's different with respect to the 60 days period is sometimes, and I did see this recently with the spate of layoffs at Amazon and Microsoft, some employees may be facing medical issues, right? And so the US immigration law does allow for unpaid leave if it is related to medical care. So to the extent that you have an employee that is up for termination or is going to be impacted by layoffs, but they are receiving medical care, instead of terminating them immediately, you can choose to put them on unpaid medical leave. And that way, that allows them to essentially save the visa so that they're allowed to continue to remain in the US whilst they receive medical care. And then once that process is over, then you can terminate them. You wouldn't need to pay them anyway because it is unpaid medical leave, and that is completely legal and allowed. So that's one thing to keep in mind should you be in that situation. We've sort of gone through this before. So if you have an employee that is facing layoff, again, they have 60 days within which to transfer to a new employer. Realistically speaking, they really have 45 days because the new employer has to file a labor condition application with the Department of Labor. The labor condition application basically certifies that there is a valid job offer and what the terms of that offer are, right? So you have to specify the position that the foreign national employee will be working. The minimum wage that is to be paid to this employee is determined by the Department of Labor. And then also the job location, because the wage is determined by the location of the position. So it's basically the Department of Labor comes up with an aggregate of what is normal market rate for that specific metropolitan statistical area. So they would determine the minimum wage. But that application at any rate needs to arrive at USCIS by day 59 at the very latest in order for your employee to continue to stay in the US. We talked about, changing of status to tourist visa or student visa. And for those of you that are in, because I see some people that are in HR positions, for those of you that are in HR and are essentially the first line between the entity and the employee, if you're being asked questions about, well, can I move to a tourist visa and can I move to a student visa and can I do all of these things? The simple answer is yes. The more complicated answer, honestly, especially with respect to the student visa, is your employees need to be very, very careful about which university they are applying to and what program they are applying to. there is one version of an education program called the Curricular Practical Training, or CPT, which is wildly popular amongst the foreign national employee population. And that's because the CPT, some schools at least, have what they call a day one CPT, which means the day that you enroll, the university would allow you to be employed in a profession that is directly tied to your academic degree. Right. The reason that I caution HR and I caution employees on this is because, believe it or not, US immigration, a federal agency, has of their own volition in the last 5 years created a university, knowing it to be fake, allowed foreign national students to enroll in said university, and then put those very same foreign national individuals into deportation and removal proceedings, saying you essentially engaged in fraudulent behavior and that this was a fake university, right? So there are universities out there, but just be careful. So to the extent that you are having to sort of play first line between, you know, the employer and any employees that are impacted by this, I would say speak with Immigration Counsel that is in a position to advise you and help you, because you don't want to be the one that's directing them either to do or not to do anything, especially with respect to the student visa situation, because it can get really murky very, very quickly. The effect on layoffs is, again, now if you, to the extent that you have L1 employees, and I don't want to get into the weeds here, but an L1 employee is a foreign national transfer, right? And so if you are an entity that transferred an employee from a foreign office, whether that's Asia, Europe, Canada, whatever, they are not eligible to transfer to another employer. They are essentially looking at 60 days and then having to leave the US within those 60 days if they are a foreign national transfer, if they were transferred to your office from a subsidiary or affiliate in a foreign country. They do not have the option of going to a different employer. They have to stick with you, or they have to go back to the entity in the home country. To the extent that you are considering layoffs, the one thing that I want to make clear is with respect to your foreign national employees, because we saw this earlier, if you are thinking of doing a period of furloughs prior to doing full layoffs to see if the company can recover, furlough is not an option for foreign national employees. They cannot be benched, they cannot be furloughed. Also, to the extent that they are being terminated from their employment prior to whatever term that you had previously agreed to at the time of onboarding, the employer is responsible for providing them reasonable cost of airfare back to the home country. You are expected to provide that for the foreign national employee, not for his or her family. If the foreign national employee says, I don't want the return transportation and I don't want the cash equivalent, have them sign some sort of agreement saying, we offered it, it was refused, put it in their personnel file. But you are by law required to provide reasonable cost of return transportation for the foreign national employee. Number two, make sure your I-9 forms are up to date and that you have that system in place for notice on the I-9s as to what the last date of employment for the foreign national employee, actually for all your employees, whether they're foreign nationals or not. Anytime you're doing terminations, I would recommend that you annotate your I-9s, because that directly impacts how long you have to maintain your I-9s. The requirement for I-9s is that you maintain I-9s for terminated employees, either from 1 year from the date of termination or 3 years from the date of hire, whichever is the longer period, right? And so with respect to your I-9 compliance requirements, you want to make sure that you annotate each I-9 for each terminated employee as to their last date of work, and then on whatever your systems are for keeping track of when you are able to purge your I-9s, you keep that information there so that you're not facing undue liability. I'm going to skip the O1 because, again, this is more for, as I said, mini Einsteins, and I don't know that, you know, necessarily all of your employees would qualify for these two. But I did want to, again, go over the employer responsibility, specifically with respect to foreign national employees. So like I said, number one, you cannot bench or furlough foreign national employees. If the employee was on an employer-supported visa, it is your responsibility to at least offer them reasonable cost of transportation back to the home country. You do not have to do that for family members. To the extent that the employee was on either an H-1B or an L-1, one of the first steps that counsel on your behalf would have had to do is to file a labor condition application with the Department of Labor. As an employer, it is in your best interest to withdraw that application ideally within 10 days of the termination of the foreign national employee. Failure to withdraw may subject you to liability down the road, where the foreign national employee says, I was not paid for XYZ period, even though I worked. If the employee did not, in fact, work that period, but you had an LCA in place, that is going to come back to be an issue for you. So to the extent that you have foreign national employees and you are terminating them, one of the other things for you to do would be to make sure to connect with your counsel and have them withdraw the LCA, which is the labor condition application. And then once that's been withdrawn, send a formal written request to USCIS asking them to withdraw the underlying immigrant visa or the non-immigrant visa. And then I did talk about the annotating the I-9 because that is a big issue with respect to I-9 compliance, particularly, again, if you are an entity that has a higher number of foreign national employees. So I would say 50 foreign national employees or more. You are at higher risk of site inspections and unannounced audits from the Department of Homeland Security and Homeland Security Investigations, otherwise known as HSI. And I've had some clients that have had these unannounced visits from HSI. They are not fun. So you want to make sure that you've got your I-9 compliance in place, that you have all of your documentation that you are required to have in personnel files specifically for foreign national employees, that you have those systems in place and that those systems are up to date. It doesn't help to have, I-9 audit done in the year 2000 and nothing since then, because you don't know what's lurking there. So that's one of the other things that I would recommend is if you've had a mass layoff, or if you're planning to do a mass layoff, if you've had layoffs in the last 5 years and you haven't done an audit of your I-9 files, I would very strongly recommend that you do the audit, hire an immigration attorney to come in and do the independent audit for you. That would be in your best interest. Right. Unlikely that a lot of you have this, but to the extent that you have petitioned for an immigrant visa for your employee, and there has now been a layoff, that depending on what part of the process that application is in, because an immigrant visa application goes through 3 separate agencies. We go through the Department of Labor, we go through USCIS, which is the US Immigration and Citizenship Services, and we go through Department of State, right? So we have to interface with 3 separate agencies per immigrant visa application. Depending on which agency that petition is and at what point of the process that petition is. If you have a petition in process for a foreign national employee and there is a termination, 90% of the times, unfortunately, that petition is going to come to a screeching halt and the employee is out of luck. They cannot proceed any further. There are some exceptions to the rule, and that basically requires the application to have been approved and pending a visa approval for more than 180 days. If it has been approved or pending for more than 180 days, then the employee gets the benefit of the doubt and the employer doesn't get to stop the process from moving forward. But otherwise, if there is particularly mass layoffs, it essentially brings all immigration processing to a screeching halt for that employer and any employees that were a part of that application process. So that's all I have. I know we covered quite a bit, both on the employment as well as immigration side of things, but if you have any questions, again, feel free to either put those in the Q&A and we are happy to answer them.
Kripa, since we have just we have some more time. I was wondering how often we get calls on the other side where someone's hiring someone who was recently laid off and is on this super short time crunch to maintain their status. Is that something we help employers with frequently? Is there, what is,
Yes.
and how quickly can we usually get something like that turned around if they're on such a short time crunch?
So honestly, for us, and we've actually done this as early as last month, we had two that we moved from one employer to another, and we did that in 2 weeks.
Okay, so it's a much better process.
Yeah. Yeah. They need to act really quickly. The other thing that we do, that the team that here does on the immigration side, is the I-9 audits. And we expect that to actually increase significantly. I don't know if how many of the folks that are joining us on this webinar are aware, but US immigration, although it is a federal agency, is not funded by the federal agency, right? They are fully fees and liability funded. And so it is in the service's interest to do I-9 audits and compliance audits and assess fines, because that's essentially how they earn quite a bit of money or the revenue for their operations. And so last year we didn't see too many I-9 audits, but this year we are expecting them to ramp up, also because they have hired more HSI officers. We're expecting them to ramp up. The largest fine ever paid for I-9 audits was against a tree trimming company, Asplund, and that was a $5 million fine for I-9 irregularities, right? The one below that was, I think, a $3.5 million fine against Abercrombie and Fitch a few years ago. And so the fines can get really big, because it's $1,000 per error, not $1,000 per form. It's $1,000 per error on your I-9 forms. So it really is in your best interest to at least do the I-9 audits and make sure that those are clear. And again, as always, on the employment side as well, I know there are liabilities. So yeah, anytime there's expectation of termination or expectation of layoff, I think speaking to attorneys is crucial.
Great. Well, if anyone wants to contact us, feel free to give us an email or call us on our main line, or just contact your attorney that you already know at Carr Tuttle Campbell. They'll direct you to us. They know us. And we really thank you for coming today.
Thank you very much. You've got our contact information. Feel free to reach out if there's anything that we can help with. But thank you for your time.